people that make the laws, I guess, view the fact that if we're making somebody homeless, they're going to become a burden on the state. So we'd rather have few more checks and balances because we're making people homeless here, whereas that chap with the retail unit, he's just going to lose potentially a business but not necessarily become homeless. You're investing some serious money. It can be as little as, I don't know, £50,000 up to several millions of pounds, and if you don't have the right legal advice, representation, you get something wrong, or that you miss something, or your lawyer misses something, you could be down several hundreds of thousands of pounds. But if something goes wrong, then it's a contract everybody's poring over. Look, what are my rights, what are my remedies here, what options do I have? That's when, you know, there's several thousands of pounds you hand it over to your lawyer, hopefully comes home to roost, and hopefully the contract stands up, and like a parachute, it opens and lands you safely with limited damage, maybe not broken bone, but at least you can get up and live to fight another day. But if that contract fails for any reason, doesn't stand up to scrutiny, you know, you could be down a few £100,000 and suddenly be looking to your lawyers, look, how did you miss X, Y and Z? The lawyers had missed it. It was in the local authority's search, but the seller hadn't, in various property information forms, so hadn't disclosed that there was a live enforcement notice. Somehow the lawyers on the other side had also missed it. It got quite messy, really.
Wow.
So the end result was the seller was down 80,000 at the end of it, had to settle.
Do you think there are any other legal issues or legal aspects that property investors sometimes may tend to overlook, but then could have significant ramifications?
You can't just change the locks. Criminal offence, and we've had one person that I know who got a 5-year jail sentence.
Real estate investment has a lot of pieces to the puzzle, but whilst you're at it, you need to have a strong legal advisor, an experienced one, who's going to help you through all the obstacles that come with property acquisition, investment strategies, and risk management. You could buy a property through auctions and you won't even need any legal advice, or you don't take any. But the next thing you know, you've bought a property and you've been served an enforcement letter that you need to shut the building down or take it down entirely, maybe because it was built illegally without planning permission. So today we have our esteemed guest, someone with a wealth of experience and knowledge, who is here to share with us some tips and knowledge on smart moves that we can make on our real estate investing journey. Arif, thank you so much for joining us here today.
Vas, thank you. That's quite an introduction. Pleasure to be here. Thank you for the invite. Yeah.
Not at all. Arif, could you share with us your background and experience? What led you into becoming a property conveyancer and a business owner in this legal perspective?
Well, that's quite a tale, really. I mean, we probably haven't got the time to go into all of that in much detail, but I guess, I mean, in terms of my background, I actually started in a religious seminary. I ended up doing an external law degree with the University of London, largely self-taught. So got my degree and then did my professional exams, managed to get into small high street practice in small East Birmingham. I was there for a short while and then migrated from there to another practice in Handsworth, eventually qualified with a firm in Walsall. And once I'd qualified, I became a locum lawyer, so travelling up and down the country, Coventry, Walsall, Nottingham, Leicester, Lincolnshire. So, you know, fair bit of commuting. That was very good, certainly, you know, broadened my horizons, allowed me to gauge good and bad practice. So then my previous boss, he said, look, if you're free, it'd be great to have you back. So I went back to my old firm in Handsworth. Plus my wife was getting a little bit, young family, said, look, I'd rather have you at home rather than staying in hotels and travel lodges and what have you. So I went back there. I was there for another couple of years and then left there in about 2014. Locumed for about a year and set my own place up in about 2015-16. We were in this building.
Yes, you were.
For a number of years, yeah, from about 2015-16 to about a year ago. And then moved to our current location just at the bottom of Colmore Row, Whittle Street. So it's been there's been a lot more happening in that time frame.
Yeah, you've got another branch in Redditch as well.
Yeah, so we've had a lot going on. But yeah, that's it in the headlines, really.
So did you always want to be in this legal realm since you were a child?
Yes and no. I think, to be honest, I was probably looking at medicine for a great number of years, but then had a biology class and we had to dissect an eye or a heart or something crazy like that. I said, you know what, this is really not for me. So at that point, it sort of veered to law. Yeah, I think that was the other way, really. But yeah, so since probably about secondary school, you know, I think I'd sort of decided that I think medicine's not for me and I think law's the way to go.
So what is it about law that keeps you so hooked into it?
Well, there's different areas of law. I think I should also add that my dad's uncle, he was the Chief Justice in Uganda so he was the most senior judge in the country at the time.
Oh, wow.
So he came back. So he was quite influential in some regards. So he had always many a tale to tell. So he then, after left East Africa, came to the UK. Then he got appointed as a High Court judge in Hong Kong. After he retired from there, he became the Chief Justice of Brunei.
Wow.
So he's very close to the Sultan of Brunei. He was there for 8 years and then retired and moved to London. So he had a lot to do with it. You know, he sadly passed away a number of years ago now. And at the time, I think his biggest highlight was he actually heard the case when the Sultan fell out with his younger brother. It was actually, at the time, it was actually the largest sort of corporate case. I don't know how many billions went into. And his brother instructed Clifford Chance in London, which was at the time probably the largest law firm, to fly over and make represent. And he was just proud that he was the judge presiding over the matter.
Yeah.
And then they appealed it to the Privy Council, if I remember right. Yeah. In those days.
So do you think...
And his judgment was upheld. So stuff like that. So that sort of veered me in this way. But I guess the other point is, in terms of my line of work, I do mainly sort of commercial, corporate type of work. That's very different to perhaps someone who does family, who does immigration or general litigation. So each area has its own nuances, has its own quirks. But in my particular field, it's good. Because this may not sound very good, but the reality is my line of work is just making rich people richer, really, or helping them to progress in their various businesses.
So do you think it's your uncle that may have been one of the factors that you got into law?
It's certainly a factor, yeah, definitely.
Yeah.
The fact that we didn't have any of the lawyers in the house. We had, plenty of doctors, engineers, opticians, teachers, you name it. But he was the first lawyer. And I think him being a judge as well, quite a senior judge, I think had a big part to play, yeah.
Yeah. So there are a lot of different aspects that you are experienced in, evictions, whether it's immigration or all that kind of stuff that your firm handles with. But when it comes to real estate, property conveyancing, how important do you think your role is in the lives of real estate investors?
Very important. I mean, look, you're investing some serious money. It can be as little as, I don't know, £50,000 up to several millions of pounds. And if you don't have the right legal advice, representation, you get something wrong, or that you miss something, or your lawyer misses something, you could be down several hundreds of thousands of pounds. They're very serious, and things do go wrong. I mean, commercial contracts, as you know, I've probably mentioned to you many times over the years, perhaps, it's like a parachute. We can do a multi-million-pound deal on the back of a handshake, which is fine, provided nothing goes wrong. You get paid, I deliver the services, all good. But if something goes wrong, then it's a contract everybody's poring over. Look, what are my rights? What are my remedies here? What options do I have? That's when, there's several thousands of pounds you handed over to your lawyer, hopefully, comes home to roost, and hopefully the contract stands up, and like a parachute, it opens and lands you safely with limited damage, maybe not broken bone, but at least you can get up and live to fight another day. But if that contract fails for any reason, doesn't stand up to scrutiny, you could be down a few £100,000 and suddenly be looking to your lawyers, look, how did you miss X, Y, and Z? So it's a very serious role, very important role, and can have life-changing consequences if things don't go to plan.
So as we're aware, when it comes to renting properties, we get... for a single property that may be empty, we can get hundreds of tenants that may be interested in it. But we have to pick the right one to ensure that they not only pay the rent on time, they also maintain the property very well. So it's about picking the right tenant. It's not just someone who, say, is employed and has previous landlord reference check, etc., etc. It's about picking the right one. Do you think when it comes to property conveyancing, we've got so many other solicitors out there. Do you think there's a similar aspect to it as well, picking the right solicitor to represent you?
100%. I think, look, at the end of the day, there's well over 100,000 solicitors registered in the UK. Not all of them are property lawyers. But getting the wrong lawyer can have, as I mentioned, very serious consequences. A lot of people, perhaps lawyers, not just lawyers, but in any trade, they might, say, hold out that I have specialism in X, Y, and Z, but the reality is they don't, and they just, wing it, for want of a better expression. And they might get away with it for a number of years. But again, if something goes wrong and they have winged it and they miss some glaringly obvious signs or issues or pitfalls, they're going to have a very unhappy client and probably looking at a negligence claim. So it's hugely important. And not only that, but how deals are structured. It's not just the legal element. We get clients coming to us and might have a deal, say, look, this is what we're proposing to do, this is how we want to do it. And a good legal brain can say, okay, I think that's good, we can achieve that outcome, but I think how you're proposing to structure this deal, you might want to consider X, Y, Z. We can restructure it, may get some tax relief there, you may have additional security, And I think it might be more fluid transaction doing it this way as opposed to doing it, the way you have planned out as a client. So yeah, definitely, I think the right lawyer can make a huge difference. Plus, negotiating is very important, especially perhaps some more on the corporate side of things at times. You can have a Teams meeting with maybe 2, 3, 4 lawyers on there, each one giving their 2 pence worth, and you have to be able to hold your ground. Not all lawyers are comfortable in that kind of environment. Can feel a bit of under pressure, be a little bit unsure about what they do and don't know, especially if you've got big firms on the side. The general mindset is because they're bigger, they must know more and must be better. That's not always the case. So you're going to have someone who's got the confidence and you can stand their ground for you. So the right legal representation can make all the difference.
Right.
Yeah.
So for a typical landlord or investor, when they buy a buy-to-let property or a block of flats or commercial, whatever that is, typically they'll go through a phase when the solicitor would advise them to go through and undertake searches.
Yeah.
So for a typical investor that may not know what these searches are, what type of searches are out there, what they represent, how do they mitigate these risks? Could you elaborate a little bit on that?
Yeah, look, property searches are part and parcel of vast majority of property transactions, and I think you've sort of hit the nail on the head a little bit. Those, let's say, who are more seasoned property investors very often say, look, we know the area, we know the property, we don't need any searches, no mortgage finance, it's a cash transaction. Maybe we just get them sign a simple disclaimer and on they go. But if somebody's doing it for the first time, maybe a little bit unsure, and we'd always recommend getting a certain suite of property searches. You'll have the local authority search. So these are inquiries which are made with the local authority. There are preset inquiries or questions we can say which the local authority will answer. And yes or no answers, or sometimes more information is provided. This could be down to planning, building regs, road schemes, designations for certain parts of the city, forthcoming proposals. For developers, things like the community infrastructure levy, whether what the charging rate is, etc. So there's a whole array of information that comes out. Very often, if you're buying a residential property, there could be issues with planning enforcement notices. Somebody may not want to disclose the fact that they've built an illegal extension and been served a planning enforcement notice. That can come out in the local authority search. We had a case a few years ago where a property was bought and sold with a live enforcement notice. Basically, this chap had built 4 rooms in the loft, converted a loft, no planning, no building regs, had been served with a notice, failed to disclose it to the other side. The matter completed, the lawyers somehow missed it as well, but anyway, the matter completed. Post-completion, we've got quite messy, let's just say that,
So a local authority is meant to pick that up?
No, not local. The local authority had picked it up, the lawyers had missed it. It was in the local authority search. But the seller hadn't, in various property information forms, hadn't disclosed that there was a property, live enforcement notice. Somehow the lawyers on the other side had also missed it, and it got quite messy, really.
Wow.
So the end result was the seller was down 80,000 at the end of it, had to settle.
I recall you mentioned that story to me.
Yeah, you have these ones.
So that's local authority.
Yeah, we have local authority. You didn't have water and drainage, you just want to make sure that is connected to water mains, is connected to the drainage, etc. That kind of and they also provide a map which just gives you a rough indication as to where the water and drainage pipes are. It's not wholly accurate, but it gives you a good indication as to where these drainage pipes are. You then have an environmental search, which is becoming more and more important with changing climate, etc. That will just detail contamination issues, mining issues, historic coal mining, that kind of stuff, flooding, which can be very important in certain parts of the country as well. So that kind of stuff comes out from there. So you have a whole suite, and then you have more specialist searches for developers. They might want to do certain additional planning searches, they might have additional utility searches. They're a bit more involved, etc. But that's not for everybody. That'll depend, transaction specific really.
So for a typical landlord that may be interested in buying a property through auction, the sellers at many occasions do not provide these searches, and you do not have the time to pay for these searches or get these searches. Or also you don't want to risk the money to get the searches done, not knowing that you'll be the successful bidder at the end of it.
Yeah.
So in certain occasions, people take out insurances against these searches.
Yep.
So how does insurance protect the purchaser in case, say, there was a contamination issue on site, but because they couldn't take out the searches to identify that there is contamination on site, they've got insurances in place. Now they've bought it, they're trying to refinance, but the lender's uncomfortable. How would insurance fit in a picture? How?
So insurance is never obviously the first port of call. So insurance, you already want to be taking out where you can't remedy something in the normal course. So for example, you've not been able to obtain searches or they've been delayed or whatever. Then you can get some insurance to bridge that gap. So you can have delayed search insurance or no search insurance. And the idea with search insurance is that in the event anything adverse comes out, let me rephrase that. In the event that had you done searches and something adverse would have been revealed, then the insurance is there to cover that, I guess, sort of liability. And what they'll usually cover is just the loss in value or to defend a claim. So, for example, if you had an enforcement notice, they normally cover the costs of defending any legal proceedings that are brought in relation to that adverse entry or that enforcement notice. And they will normally cover the loss in value. So if property is worth 100,000, because of the adverse entry now, the property values drop to 20, drop by 20 or 30,000, they will usually cover that kind of
So
loss.
it doesn't really remedy or fix the issue at stake.
You can't fix the issue. It's just an indemnity, isn't it? It's just a monetary sum that they will agree to cover. So you can't fix the issue. The only way to fix the issue is to remedy it, actually remedy it. All right.
So I suppose it just protects your assets worth.
Yeah, it'll just put you back into a position you would have been in financially had it not been for that adverse.
But then I suppose at the end of the day, it's upon the new buyer to accept in buying a piece of property that has these issues. Although it has insurance in place, insurance is insurance going to cover the gap of whatever the purchaser is willing to pay, or it's got no?
No, it'll just cover the value. So you have to specify the limit of indemnity. So 100,000, 200,000, £500,000 or £1 million. And if as a result of an adverse entry being disclosed in a search or comes to light subsequently, they will usually cover the loss in value, and if there's any legal proceedings which follow, to cover the cost in defending those proceedings. But what they won't cover, for example, if you have to bulldoze a house and rebuild it, or you have to make structural changes, they won't cover those sort of costs in most policies.
So it seems to
it's
me
just
that
a loss in value. So the surveyor will come out because of this adverse issue in the property, we can only value it at X. All right. And they'll give you the difference. But if you're now going to cost you 100K to remedy that defect outside of the legal arena, so there's building works to be done, that invariably will be excluded.
So it seems to me getting searches is quite a crucial point of view.
Yeah, it's always a better way. It's like any insurance policy, they can find a way not to pay. They'd rather not pay than to pay. And if they can find a way to avoid the policy, I'm not saying that they practically do that, but if you avoided the policy by inadvertently contacting potential beneficiary of any adverse entry or things like that, or fail to disclose something when you should have, that's sufficient ground to say, well, look, had we known X, Y, and Z, we would not have insured you, or we would have quoted you a higher premium. So you've got to be alert to these things.
From an accounting perspective, buying a property through a limited company in some occasions may work out more favorable rather than buying in their personal name. But in terms of a legal perspective, does it make any difference at all?
Well, yes, it does, because they're two different legal entities. So you can buy in your personal name, you're a legal entity in your own right, and your limited company is a separate legal entity. A lot of people sort of, conflate the two, but they are two very distinct things. Either the asset belongs to the company or it belongs to you personally. It's not two at the same time. So if it's in your company, it doesn't belong to you personally. And if it belongs to you, it doesn't belong to your company. And the tax regime for both is different as well. So if you're in your personal name, you have self-assessment and your own sort of income tax, whereas the company will pay corporation tax, take money out, that'll be by way of dividends, etc. There's various ways of doing that. So yeah, very different. So
which way would you say is more favorable in terms of being protected?
There's no hard and fast rule. There's no, this is the right way or the wrong way. It just depends on personal circumstances. The general view would tend to be that if you're going in to buy several properties, so you want to buy 3, 4, 5, 6, 7 plus, then arguably it'd be more tax efficient perhaps to have it by way of a limited company as opposed to in your personal name. That's generally the
fact is, so do you think it's only the accounting or tax that should be factored in rather than any legal factors to say that
legal factors, yeah. But look, the property is owned or it's not. So whether you own it in your company name or in your personal name, There's not a huge difference. I guess if you buy it in your company name, the advantage you have, you can sell the company with the assets. So you just do a share sale, and the company gets sold with all the assets in it. You can't sell yourself. All right, that's a different arena altogether.
Absolutely, yeah.
All right, if you buy all the properties in your personal name, you have to do an asset sale. You've got to sell each individual property.
Yeah.
And in which case, the buyer's going to have to pay stamp duty on every single asset that it buys. Maybe other types of reliefs actually, but with a company, you can build up a portfolio of 30 properties and sell the company with the properties, for 30, 40 million pounds. And the tax regime will be very different because now it's a corporate transaction, and you're selling the companies, selling the properties as part of the company.
Right. So moving on, there are a lot of people who buy properties today to convert them or to refurbish them to add value, maybe because of high interest rates that buy to let just doesn't work out at the moment with interest rates being so high and the returns you're getting. So they're always seeing how to add value. So one concern that quite comes up, I think people struggle to understand what a party wall agreement is and what they can do to mitigate those risks or how to work around it if they have issues with the neighbors or whatsoever.
Okay. So look, party wall, the party wall at 1996, again, off the top of my head, it was basically brought in to regulate precisely that sort of situation where you've got a wall which divides two properties. All right, half is owned by one neighbour, half is owned by the other neighbour. So it just provides a framework whereby a notice can be given, the works can be stipulated, and then it provides an arena for, in the event of a dispute, how that dispute can be mediated out and resolved, right? Party wall award. But generally, these things are surveyor-led, so lawyers don't get involved so much. So this particular arena is primarily, surveyor-led in most cases. But it's important, I think, before you start, if you're going to be digging within 3 to 6 meters of your neighbour's boundary, that kind of stuff, you're going to be knocking on the wall or knocking it down even or rebuilding it, you need to have a party wall agreement in place. If you don't, there can be all sorts of fairly draconian consequences. So you want to get that done, get it signed, get it all in place. At least both parties know exactly where they stand. So, yeah.
But when it comes to converting the property internally and not doing any excavations or extensions to your yard, does that still matter?
No. If it's all internal and it doesn't impact or affect a party wall, then no, you don't need a party wall agreement, So it's only if it's going to impact the party wall and, arguably cause a disturbance and or nuisance for your neighbour. So if your neighbour's going to be knowing, if you're putting a little picture frame on the wall, you don't need a party wall agreement for that. Just put a nail or a screw in the wall.
Yeah.
But anything more than that, which is going to, objectively create disturbance. And I think you should consider a party wall agreement.
Right. So we have spoken about quite a few important things that property investors need to be aware about. All the importance of for property investors to do searches and how it can backfire on them for those kind of property investors that tend to overlook searches. People who take out insurances, how it backfires on those, perhaps because insurance does not really remedy the issue, rather can just cover the loss of value of the property.
Yeah.
So I guess my question to you is, what other mistakes you reckon the property investors tend to make, they overlook and could have significant ramifications?
Yeah, definitely. I think the other big one is our covenants, restrictive covenants. So if you've bought a plot of land or even a property with a view to developing it, perhaps knocking it down, building another property or some land on which you want to build some houses or flats, there can be restrictive covenants which impede your ability to do so. So, for example, you can only use it for a medical practice or retail, and you want to build, residential units. You've got a problem. So that's quite common as well. It was again for the simple reason at auction, very often people don't check the title documents, or at least have them checked by a competent lawyer. Gets overlooked. They acquire the asset, the property, and suddenly find that, they could have a breach of covenant on their hands if they proceed with the development. You're then left with the task of trying to find the beneficiary of those covenants, trying to get a restricted covenant removed, failing which you've got to make an application to the land tribunal to try and get that removed. I mean, there's all sorts of, complications that can arise. And in the worst case scenario, if that can't be dealt with effectively, you're left with a situation that you can't develop the land as the investor intended. So again, a very common scenario outside of searches. Yeah.
So you reckon, other than searches, it's the auctions that people need to be aware
I
of
think
quite
so.
a bit.
Yeah.
And you think, is that where people tend to overlook and make
I think so, especially those who are perhaps a little bit inexperienced. I mean, those who've got experience and been doing this, they can usually have a quick review of the auction pack, title documents, and can usually get a gist of where it's at, and are probably seasoned enough to have a look at the title register to say, look, there's certain covenants in here. Maybe I should just get a legal eye to have a look at these and give me an opinion here. But those who are doing it for the first time, who have never really been in an auction environment or bought a property at auction, may not necessarily go through that process, and they're usually the ones that get caught out.
So having a solicitor there to make sure to go through all of this is quite important. But I think the reason people tend to overlook that is perhaps because they think that if they involve a solicitor early on, I guess it's about weighing the risks, isn't it? Because if they involve a solicitor earlier on, they're thinking, I presume, that I'm going to spend X amount on a solicitor looking at the legal pack, and then they're going to review it all, and then I may not even be the successful buyer and the bidder. Someone might outbid me. Yeah. And perhaps that's the reason, I presume, one might want to overlook having a solicitor review the legal pack.
100%. So, well, that's the thing, penny pinching in that scenario can cost you hundreds of thousands for the sake of a few £100s. But from a legal perspective, we generally try to avoid that as well. Yeah. If I'm honest with you, because look, for the sake of £150, £200, we could have a liability of £300,000. Because if we miss something as lawyers for this on the back of 150 quid, and client buys it at auction, suddenly it turns out there is a restricted covenant or a legal issue that we didn't pick up because it's just a quick skim read. For the sake of £150, do we want a headache from the client? Well, I bought it now. I bought it because you guys said it's all good. Yeah. So from our perspective as well, we may not necessarily be too keen to just do a precursory review, unless we have a few caveats here. So look, it's just a quick skim read and, a bit of a disclaimer. Say, look, that's all we're doing. We don't want to have to produce a full report on title on the back of a few £100s. It's just not worth the headache and the time. So you'll often find that lawyers as well may not necessarily want to take on that liability for a few £100 unless they have a good rapport with the client and they're happy to say, look, no problem.
Fair enough. So coming back to auctions now, a lot of times people tend to pick up properties in auctions that are perhaps already let, right? And they're income generating assets. In some occasions could be residentials, in some occasions could be commercial. Yeah. So from a legal perspective, when someone is looking to buy an income generating asset, or even if it's not auctions and say it's just a private sale, what is the first thing or first few things that you would try to look for in the, perhaps say, the tenancy agreement to just ensure you are getting what you're getting?
Well, it depends if it's a commercial property or residential. It has two different sort of procedures, if I can perhaps use that word. So for a commercial lease, what you're going to be looking for, and the nature of the document is completely different. Well, not completely different, in a large part, very different to what you're getting in a residential tenancy. Residential tenancy, in a short hold tenancy might only be a couple of pages, whereas a commercial lease could run into 40, 50, 60 pages. So the implications are very different. How you obtain possession is very different. So for a residential property, you need to get an order for possession and potentially follow that up with an eviction order. For a commercial property, non-payment of rent can result in forfeiture, which doesn't necessitate a possession order. You can just turn up and change the locks, providing certain factors are met. So the regime is very different, primarily because I guess the government or the people that make the laws, I guess, view the fact that if we're making somebody homeless, they're going to become a burden on the state. Yeah. So we'd rather have few more checks and balances because we're making people homeless here, whereas that chap with the retail unit, he's just going to lose potentially a business but not necessarily become homeless. So we'd rather facilitate the landlords in that arena and constrain them slightly in this arena. That's the long and short. That's generally the thinking behind it.
So for an investor who hasn't bought the property yet, is there anything that he or she can do to check whether the tenant is fulfilling their obligations before buying the asset?
That would be the usual sort of due diligence inquiries, before contracts are exchanged. So invariably, you'd have a series of inquiries which you would want to send over to the sellers, solicitors, confirming simple things that there's been no breach of covenant in be it the tenancy or the commercial lease. Rent is paid up to date. It's a rent deposit deed. What terms is that held? Where is it held? Is it accruing interest? These kind of things really. Whether there's any rent reviews, if so, how they've been completed, is there a memorandum attached to the lease, all this kind of stuff. For residential stuff, you'd be wanting to check a few additional things to make sure all the requisite requirements have been met prior to giving the tenancy out, ensuring the deposit has been protected properly in the right scheme. That wasn't a big thing several years ago, but it is now, resulting in fines, your carbon
They can sue you up to 3 months
They
rent,
can,
can't
that's
they?
right. You've got your, not the smoke detectors now, carbon monoxide detectors, that kind of stuff, the EPCs. So you've got a whole raft of things you need to make sure have been done prior to the
And this is the whole
tenancy coming
solicitor's
through.
bull. Isn't
Yeah,
it?
I mean, that's part and parcel of what you'd be wanting to make sure your lawyers check out for you, really.
So one thing you mentioned is that you would get in touch with, say, the seller's solicitor to perhaps get a disclosure if the tenant has forfeited any of the obligations or whatsoever. Can that really be considered as something for the investor to hold as grounds, as a solid ground to rely on that?
Well, it depends. I mean, different investors will be looking at different things, I guess. I mean, some may say, okay, we appreciate the tenant's a bad tenant. The previous landlord hasn't ticked certain boxes, but the bricks and mortar value is very good. I'm getting some kind of an income, albeit legally, if I need to take action, there may be certain deficiencies, maybe a bit of a headache. They cost me a little bit more. I may not be able to use, let's say, a Section 21 procedure. I might have to go through a Section 8, have a hearing. Discretionary grounds may or may not go my way. But the location, the value is still good. I'll take a chance. So it's horses. It's horses for courses. Yeah, there's definitely a risk. Yeah. So some are risk averse and say, look, unless all the tenancy boxes are ticked, I don't want to take on a tenant which I may struggle to evict in the event of there being difficulties tomorrow.
So you mentioned when it comes to commercial evictions, if someone, let's say, if someone is on a fully repairing and insuring lease and they're not paying the rents, so essentially they've forfeited the lease. So you could possibly, I presume, change the locks on them.
You could do, but again, there's certain caveats to that. For example, if you're planning on forfeiting the lease, it's quite a draconian step. You need to ensure you've not made any rent demands before you forfeit the lease, otherwise you could waive your right to forfeit. A lot of landlords get caught out on that. Two, there's nothing stopping the tenant applying to court for relief from forfeiture. So you've changed the locks, you can apply to court to say, look, I know I haven't paid the rent, but here's the 10,000 in arrears. Look, Mr. Judge or Mrs. Judge, let me back in. And invariably the court will, in most cases, I guess, everything being equal, say, okay, rent is now up to date. The breach has been remedied, and I think we should be granting you relief here and allow them back in. So it is an important tool, I think, that landlords, have and retain. And if a tenant thinks the lease could be forfeited, it at least focuses the mind and says, look, do I really want to have a legal fight with the landlord, go to court, etc., etc. And it should, in most cases, compel them to at least behave and hopefully get the rent paid, I guess.
But then in residential, it's a whole different ballgame, isn't it?
Absolutely. You can't just change the locks. Criminal offence, and we've had one person that I know who got a 5-year jail sentence.
Really?
Yeah. So
what for?
Again, he got the conviction was quashed because it shouldn't have gone in. But the idea was that it was an attempted, I guess, sort of unlawful eviction scenario there. But it was the other way around. I mean, the aggressor was actually the tenant. But then on appeal, the conviction got quashed.
So 5-year prison.
Yeah. It's
for
up
unlawful
to 5
eviction.
years, yeah, up to 5 years. Yeah.
That's harsh.
Yeah, it's a serious offence potentially. You're making, kicking somebody out of the home, potentially making somebody homeless.
Did the person actually go to prison, or is it still in?
Yes, for a short period of time. But like I said, he then got quashed. So on appeal.
How long?
Within the year, I believe, yeah. Which is not satisfactory.
Well, still,
yeah.
no.
But I have to clarify, in this case, really, I mean, the premise for the conviction was all wrong in any event. But because of the way I think they've been handled, legally speaking, it just resulted in a very unfortunate circumstances. But the initial premise was precisely that.
So how important is it, again, in criminal defense, I presume, to have a good representative on your side?
Oh, you need somebody good.
But today, for example, if you go into Google and you just write a criminal defense lawyer, for example, you're going to get 300 options there, and the one who's willing to pay the most for advertisement is gonna be the one showing up on the top.
That's the nature of marketing, though, isn't it? I guess that's just how it is. And it doesn't mean to say that he or she is the most expensive is necessarily the best lawyer.
Yeah.
For any given role or job, that I think is a given. But yeah, it's just savvy marketing.
But could you share a bit more details on what he did perhaps in that unlawful eviction to result?
Well, it wasn't an unlawful eviction. That's the thing. I mean, he was just going to confront the tenant to get payment, but they were waiting outside with poles, and obviously he got a bit violent, for want of a better expression. but the particular chap concerned didn't actually throw a punch. So there's 4 people, 2 tenants, the landlord and somebody else. He was bear hugged from behind, but when the police arrived, they looked tenants on right, landlords on left. Who had the most blood? Who had the least blood? That's basically what it came down to.
No.
That's what it was. Yeah. So, and that's how the whole trial proceeded. But like I said, it was in the Court of Appeal. It was later, the conviction was quashed. A retrial was ordered, and at the retrial, he was found not guilty. So, with that in mind, you've got to be careful.
But I think just sharing that story just emphasizes on how many regulations that landlords are bound to and what compliancing they have to face, and many people don't even know about them. Are there a few things you can share on top of your head what compliancing the landlords have to ensure to do, and to maintain that relationship with their tenant where they're not crossing any red boundaries?
Look, I think the fundamental thing is you can't just go up and change the locks. That's the long and short. If they haven't paid rent, you've got to engage lawyers, or at least notify them you haven't paid the rent. If you don't pay the rent, it leaves you no choice but to seek possession of the property. I mean, I don't deal so much with residential landlord and tenant, but you have to go through that process. If it's within the tenancy period, then you can't use the accelerated process, Section 21. You have to go through Section 8. I think from the top of my head, I think it's about at least 2 weeks worth of arrears, or 2 months, worth of arrears that must have accrued before you can start to take possession, or seek to start possession proceedings.
Yeah, and now you even have selective licensing, isn't it? So
yes, in Birmingham.
So other than selective licensing that a landlord has to have, are there anything else the landlord needs to have to own a property to let it in today's market here?
Yeah, like I said, it's got to be fit for human occupation. That sounds silly, but that's a basic standard. EPC needs to be in place. How to rent guide. Okay, taking a deposit, make sure you've got a scheme ready to place it in. Carbon monoxide detectors, your smoke alarms, that kind of stuff really. And it would also ensure, not necessarily legal stuff here, but you probably get an agent who can probably come and give you more relevant information, but you want to make sure you've done your AML or stroke KYC so you know who your tenant is. So relevant ID documents, maybe reference from the previous landlord, and a credit check. They're not necessarily legal, but it just ensures the landlord knows who he's getting in bed with, I guess. So if you do need to take any sort of legal action, at least you've got a lot more at your disposal in terms of information to perhaps pursue a tenant should they not pay rent. And then I guess the other difficulty is often when a tenant doesn't pay rent and they vacate the property, you have no recourse because you don't necessarily know where they have gone. And I guess to hedge against that eventuality, obviously you can take a rent deposit, but I would suggest a more secure position would be take a guarantor who's got an asset or a property, perhaps a parent or somebody else. At least that way you've got 2 people to go after. You've got the tenant, and if the tenant should abscond and or prove difficult to locate and go after, you've hopefully still got a guarantor who's got a property and hasn't moved or relocated that you can then pursue.
It's definitely not just a realm where there are no regulations.
No,
I think
not
real
at all.
estate investment has a lot of
caveats
to it, things to be aware of. So is there any other story you could share with us where a landlord has gone rogue? Because I think with this kind of story, there's a lot of lessons to learn. Because I can only imagine for a landlord perhaps who may be depending on that rental income to survive, because we in our management company, we do have landlords who are retired and they depend on that rental income to survive. So they use that money from rent to not only pay the mortgage payments, but then also, to get themselves bread and butter. So if a tenant was not to pay the rent, it's not just an investment gone wrong. I think it's more of an emotional trauma that one can go into, because it sounds quite unfair. So with the lessons that you're providing, I think those kind of landlords do get tempted to go rogue, but they need to be reminded about all the
100%.
ramifications.
I think the other big area, again, an actual case that we have is, I don't want to give too many details away because he's already identified, but he's actually been on TV as a rogue landlord as well. And it very common, not I say very common, but something that's does happen from time to time. So we had a client of ours who'd had a couple of properties, converted them into HMOs without the requisite planning. Got served enforcement notices. In his mind, he had dealt with those adequately, but in the local authority's mind, he hadn't. Long story short, That's obviously breach of planning can result in criminal convictions, which they did in this case. He then ended up with a criminal conviction. The council then, the local authority, then used that criminal conviction as a basis for a Proceeds of Crime Act, proceedings. So effectively, what they said was, because you've got a criminal conviction, i.e., on the back of not complying with an enforcement notice, etc., the rent you've acquired for the last 6 years are all criminal proceeds.
No way.
So he had to repay the rent. Most of his tenants were claiming housing benefit in any event, but I think regardless, again, it's not my area per se. So they'd use breach of planning to procure a criminal conviction, and then use a criminal conviction to seek recovery of the rent paid by way of Proceeds of Crime Act proceedings. And that's why for 6 years, and it was just short of £500,000 he had to repay across his properties.
So what if the owner...
And we have a client now who's again got a few properties and hasn't obtained planning, converted them into HMOs. Council have become aware of that fact. It's served an enforcement notice. So watch this space, I guess. I don't know whether.
So does it matter if the owner is a legal entity, a limited company, or a person?
No.
It doesn't really matter.
No.
So who would they go after? Would it be the director or the shareholder?
Well, if it's owned by a company, then they can't go after the director, but they'd go after the company. So if for example the company owns the asset, it doesn't make a payment, they can usually get an order, some kind of order for sale, to sell the asset to recover the proceeds of crime.
Yeah, but then I suppose when it comes to these, like the planning issue that you just told me about the story. So I suppose if a company bought an asset that converted it into a HMO without relevant planning or HMO licenses, and then was sent an enforcement letter from the council. Yeah. So I suppose the person benefiting, or the larger shareholder would seem to be more protected if he bought the asset in a limited company rather than buying it in his own name.
Well, we touched upon this earlier, if you recall. So an individual is an individual. Limited company is a separate legal entity, and that has its own implications. So you can't go behind what they call the corporate veil to go after the directors unless, there's very tangible fraud, or, and that threshold is quite high as well. It can be quite difficult to prove. But just because you've got a limited company doesn't mean to say the directors cannot be criminally liable as well. You have something called corporate manslaughter, because you can't imprison a company, but the directors or shareholders or whatever, and again, it's not my area, but they can be found criminally liable on behalf of the company, as it were, because they're the officers for the company, and they're responsible for ensuring that the company, which is its own legal entity, complies with the law. So they can, they can't lock up a company, but they can lock up the directors, failing to ensure that the company complied with its legal obligations.
So I guess to summarize, an investor cannot think that they can go rogue just because they own the asset in a limited company.
Yeah, I mean, they're definitely not.
Okay. So recently we were going through a sale with yourself. We're selling a property with yourself. And you send a large, pieces of documents that we need to fill in TR10 and, advising what the property is like and, what comes with the property, all the furniture that comes with the property and all of that. So it seems to me that those documents are then sent off to the buyer to say, hey, this is what you're getting. And if any information is provided that's being misleading, it seems to me that the buyer or the purchaser could then use that to sue the seller. Is that right? Yeah. So do you find investors making any pitfalls or any errors when it comes to selling properties that can cause some backfiring later on?
Look, it's not just investors, but if they're selling properties, you have to be honest and transparent, because if you tick a box to say something doesn't apply or is not the case, so if you've got a live planning enforcement notice and you fail to disclose that, or you give a positive statement saying, there's no planning issues, and the buyer relies on that and suddenly gets landed with an enforcement notice or becomes aware of it and suddenly has to demolish half a house, whatever it is, he's not going to be best pleased. So he's going to be looking for a remedy against you as the seller. So, well, look, you represented that there were no planning enforcement or planning issues per se, whatever the case may be, but clearly there were, and clearly you would have known about it. So misrepresentation can give a potential cause for action.
So wouldn't it be better to because you're not legally bound to provide the information, isn't it?
No.
Because I recall earlier on you even mentioned a story about a person who sold I think a 5
Yeah, failed to
bedroom
disclose
house,
it, and it happened. And that's exactly
and it
what
was
happened.
actually a 4 bed
Yeah.
without the planning
They
for the
did, yeah.
fifth one, and lost £80,000.
Converted the loft, yeah. So he had to, yeah, it cost him 80,000 to remedy that issue as a seller. So it does happen. You can choose not to disclose something, but if it suddenly, subsequently transpires that, you deliberately concealed it and or should have been disclosed, then, or the buyer can prove that they relied on certain information, it can land you in hot water, really. I think the other thing would be that if information is not forthcoming, is not disclosed, a buyer may be reluctant to proceed.
Fair
So if
enough.
I'm your lawyer and say, look, boss, I've been asking these guys for X, Y, Z, they're just not providing it here. I think something is suspect here, or, they've got no real reason to fail to provide this information. Clearly they would, my view is that they're seeking to not disclose
But
something
I've
deliberately and
noticed-
hide something. You may, as a buyer, investor, well, okay, you know what, I don't want to take a punt on this. Let's just move on.
But I've noticed
Yeah.
a lot of times when there are sellers who are trying to
Yeah.
sell these investment properties
Yeah.
and want to kind of protect themselves from any backfiring later on, they would write down to those questions. They would just write, not that I'm aware of, not that I'm aware of,
Yeah.
or not applicable, and just
Yeah.
keep it blank. Say in an instance like that where someone says, not that I'm aware of,
Yeah.
and then say you were served with an enforcement letter and you say, no, I'm sure you would have been aware of that.
Yeah,
Can
that
you-
that doesn't work as a blanket caveat. I mean, that doesn't, it doesn't mean that you can get away with, blatantly stuff. If it's something that you ought to have known or should have been making reasonable inquiries in relation to, simply writing not aware of isn't going to wash. I haven't got, I go to the CPD courses all the time, so it's not, I'm not an academic, but, there are cases to that, case law to that effect, basically, where, it's been found that just because you may write, along the lines of not aware of, doesn't, exonerate you from any liability, because if it was reasonable for you to have been aware of it, or you ought to have known, simply stating not aware of doesn't absolve you from liability. The assumption there is that you've made requisite inquiries or you've gone through your records, and after having done that investigation, you're now stating not aware of. You understand?
Yeah, wow.
So it's not that just because you're not aware of, the assumption there is that you've actually had a look, you looked through your papers, made relevant inquiries, whatever, and after that process, you are now determined that you're not aware of any. Do you follow?
Yeah.
It's probably better to make no comment and say unable to answer or not willing to answer.
Aha.
So you're making it clear that, look, I'm not willing to answer this question.
Yeah.
When you say not aware of, there can be an assumption or inference there that you're making that statement after having made those inquiries, in which case something like an enforcement notice you should have been aware of.
Yeah.
All right.
So I want to move on to the legal side of it when
Yeah.
it comes to financing, because at
Okay.
the end of the day,
Yeah.
majority of the investors do use the form of leverage. If you've got 100,000 in the bank, that's 400,000 pounds in real estate.
Yeah.
So I think there's a lot of lessons to be learned around the lending side
Mm-hmm.
of it. So in a nutshell, what do you think is maybe the top 3 things, or the one thing that an investor should do or needs to do to protect themselves when they're getting in bed with lenders?
Well, there's so many different types of lenders. You've got high street lenders, you've got distressed lenders, you've got secondary market, tertiary market. I mean, there's so many different types of lenders, etc., etc. Generally speaking, you'd have very little room to negotiate, because you're usually I want to say you're not necessarily your boss, but the borrower is usually the one who is in need of the money. And it's invariably going to be on the lender's terms, because they're the ones advancing the money to you.
Yeah.
So they want to safeguard their investment. They want to safeguard their borrowing. So it's usually on their terms, which you either have to take or leave. So you have very little room to negotiate. However, having said that, I do have probably 1 or 2 clients who, because of the scale of their operations, etc., and the amount of developments they have on the go, have probably a little bit more leeway with some of the lenders that they deal with. Now, these are not your high street lenders like Lloyds, Barclays, or NatWest, but more your second or tertiary market lenders who have smaller credit committees, etc., might be willing to take a bit of a view on this or that, where they can not dictate the terms necessarily, but have a little bit more scope to negotiate, because they have so much more going on with that particular lender. So yeah, in those cases you can. The other area where we have had some success is ensuring that there's capped guarantees. So
Do you mean personal guarantees?
personal guarantees, sorry, yes, that's right. So very often you find that, again, for most clients, it's an unlimited guarantee in many cases, to the extent of obviously whatever when I say unlimited, in the sense that the full extent of the borrowing plus interest plus cost, etc., it's not capped at anything, so you're in for the full amount of whatever the liability stands at. But we've had a few cases where we have been able to get that capped. So let's say if the loan's for $500,000, the personal guarantee has been capped at 200,000 or 150,000. That's the maximum liability for that individual. Which is still a partial result.
Yeah.
So there has been some scope in that, not always. Again, ultimately it'll be down to the lender, because they're the ones giving the money and they've got to feel secure about giving the money. And when you're talking about secondary and tertiary markets, usually they're just platforms. So they've taken money from other institutions or other wealthy individuals onto their platform and then lend it out. So they've got to, make a return for their investors.
Yeah.
And not only make a return, but ensure that their investment is secure. They're going to have their own issues.
Absolutely.
So, there's quite a bit, at stake for them as well. So, yeah.
So I presume from an investment strategy, they would need to ensure that the interest payments they're having to pay, they're sure that the rental income coming from the asset will pay the interest payments, and that they have sufficient savings, and whether it's fixed interest rates or tracker mortgages or whatever it is. That's from an investment strategy point of view.
Yeah.
But then from a legal point of view, you just mentioned one of it, which is personal guarantee. Some investors, maybe a newbie, would not even understand the difference between what a debenture is, a legal charge, and a personal guarantee is.
Yeah.
So are you able to shed some differences between the three of these?
Well, look, debenture and legal charge, very often these terms have been used interchangeably. A debenture is really a document that just states a degree of indebtedness. People understand in different ways, but that's all it is. And some people don't like to use the word debenture and just refer to legal charge. But very often, debentures, first of all, are really related to corporate entities. Corporate entities, and sometimes it can be floating or fixed. All right. So if it's a floating charge or a debenture, then effectively it covers the entire, all the assets and shareholding of the company. And should the company default in relation to their charge, it then crystallizes, all right, and then becomes a fixed charge. Because it's hovering around. At the moment of a default, it'll then crystallize. Whatever the company's got at that stage, or assets, shareholdings, etc., it'll just crystallize at that point, and then the company can't sort of do anything further with those assets. I'm giving very succinct manner, really. So that's what a debenture would be. So that would be usually registered at company's house. But like I said, it's used interchangeably with a legal charge. And some people don't even like to use the word debenture. So not all lenders have debentures. They just have a form of legal charge, which they adapt and use in that way.
But then what I've seen is that, say you were in bed with a company that lends you against an asset, they will take a legal charge on the asset. So that's the first charge.
The property.
On the property.
Yeah.
Then they will take a debenture on the company.
They will
so
do.
What's really why the debenture over the company if they already have a legal charge, the first charge on the asset? How does it protect them any further?
Yeah, so again, first of all, it's, if they take a charge over the company, anybody looking at a company's house will know that this company, which is all in the public domain, has so many charges. So if the lender is looking to lend and it notes all these debentures and charges that have been taken, it can make a lending decision. What's the company's turnover? It's got so much outstanding or potentially outstanding liabilities and credit. It's granted so many fixed charges or so many assets. So it forms that, gives it that, what's the word I'm looking for? I guess just makes it open, and so lenders can make an informed decision. Secondly, as part of the land registration process, the charge has to be presented at company's house before it can be presented for registration at the land registry. So land registry effectively asks for a little certificate confirming that the charge we're presenting at the land registry is effectively the same one that we've presented to company's house. We have a legal obligation to do that at company's house and then proceed with the registration at the land registry once we get that certificate. That needs to be done within 21 days of that instrument, that document, that charge being completed. So like I said, so some banks don't have debentures, and some do. And where a debenture is used, usually it's related to some kind of floating charge over the shareholding of that company.
Right.
And they also rank in the same way. So those who get in first have first priority.
Right. So I recall earlier on, off camera, you were telling me a story about how one of the clients you worked with, where it went wrong for him.
Yeah.
I think he was on a bridging loan, and unfortunately he had to travel due to family.
That's
personal
right.
problems.
Yeah.
And then he crossed his bridge for a period of time,
Yeah,
and he was in trouble. Could you
100%.
share
It's
that
not.
story?
Yeah, I had probably in the last sort of 20 odd years, probably not had too many, thankfully, but at least between 6 to 10, scenarios where bridging has gone horribly wrong. So thankfully not too many, because people know what's at stake, but it can happen. So in this case, is an individual looking to they got bridging to refurb another property, but he'd secured it against a property he'd bought and his main residential home, in the south of England. And unfortunately, during that period, sadly, his mother passed away, and then he got tied up in dealing with those formalities and the burial, funerals, etc. And that sort of ate into his 6-month bridge, which he'd got, and he wasn't able to get everything completed. Come D-Day, repayment day in 6 months, he wasn't in a position to refinance. The refurbishment works hadn't been completed, couldn't dispose of the asset. He was now being charged the very next day a default rate, and that just sort of spiraled.
What was the rate?
I can't. It was something. It was something quite heavy. It was touching perhaps 2% a month almost. So it was a very sizable. Yeah, it was a big penalty. So so in the end, it sort of just ate up all the equity and charges, and by the time receivers were appointed, unfortunately, it wasn't a great outcome really. And again, with bridging companies, because they're not high street banks, etc., and because usually they've taken money from other wealthy individuals and or institutions, they have to report back to their investors. They have to safeguard their own money, etc. So the penal rates can be quite draconian, and it's all about money. It's they don't have that personal or emotional take on things. If they did, they might be out of business. So, and this is a form of distressed lending. So it's not personal. So look, we need to recover this money. It's either we sink or you sink. So obviously we're not going to allow ourselves to sink. So unfortunately, as sad and regrettable as it is, we're going to have to realise the asset, and we wish you all the very best. And that's the long and short to it.
Wow, it can be painful. But you've mentioned that it doesn't happen as often in your experience, and you said people maybe are tending to be a bit more careful now.
Yeah.
What do you mean being careful?
Well, we as lawyers make sure that they're aware of what they're getting themselves in. And in this particular instance, I did say on several occasions, look, 6 months are going to fly by. Are you sure? I would suggest you get 12 months. If you get it, done sooner, better for you. But he was absolutely adamant. And this was the first time he'd done something like this, that it would be achievable. I said, okay, so long as you've understood and, I've done my bit, sign, and off we went. And unfortunately, it just didn't go to plan. And 6 months, it flies by. So I think obviously lawyers have a huge responsibility to ensure, especially if it's something that a client has not done before and they're not experienced, that they do go the extra mile to ensure the client fully understands the implications of what they're getting involved with. And if it goes wrong, what the outcomes are and what they could stand to lose, and where that may leave them and where they can even recover from that. Some people just find
I presume that helps quite a bit.
It's got to be done. Yeah.
So there are a lot of investors as well that I know of that are very worried or trying to be away from the concept of lending because of all the previous bad experiences that they've heard of. Not that they've experienced, but they've heard of. Because you don't want to just learn from your own mistakes. You want to learn through other people's mistakes. And I've personally also know of people who have had their assets taken over by the banks maybe because they've defaulted. So a lot of people want to stay away from this because they worry about these kind of things. And they think that, let me just bite what I can chew. And they try to stay that small. But in the other end of it, I know other investors who have super large portfolios and they're comfortable with the idea of huge lending because they don't intend to pay it back. Like, for example, I follow one of the guys, Grant Cardone. He has real estate worth 2.8 billion. But his lending on that is 2 billion. So that's a huge loan on it. Is very high. However, but when he's asked about it, he's comfortable because he knows he's not going to pay back the loan. He's training his kids how to service the loan. He's training his kids, make sure the tenants are always happy, because if they're happy, maintain the properties, they'll pay you, you'll pay your lenders, and roll that cycle on, because those assets, although they're on a loan, they're going to pay you a good lifestyle. So we all hear of these bad stories where people have been burnt, but then I also know people who are doing well. From your experience, do you know of people who are doing super well, are in bed with lenders, are working around all this compliancing? Because it sounds a bit worrisome, you know. Oh, if you go rogue and try to kick your tenant out, you could face imprisonment. That can be scary to some people with a smaller appetite. Yeah. So, in your experience, are there people who are doing it all well and are scaling that business?
Yeah, definitely. Look, lending is necessary to, I think, for most people to get off the ground, unless they've got deep pockets, or, you know, the parents can bankroll their operation, or they come from wealth to begin with. But for most people, to get things off the ground, they'll have a deposit, they'll need to get a loan and get the ball rolling. So to scale it up without deep pockets, you have no choice but to get lending and finance in place. You can't scale it up otherwise, unless other things come into play. But from the average Joe blog, that's what they need to do. But the idea that it should be leveraged to that extent doesn't sit well with me. I don't think that's necessarily a sensible strategy. Horses for courses, each to their own. But I have clients who certainly use finance to get off the ground, and over a 20, 30-year period, now have zero finance and probably in excess of 30 to 40 properties which they own outright, which now means that the rental income that they earn, less tax, goes straight into their pocket. And don't forget, if you have a loan, you're paying interest, and interest is an additional expense that you could avoid if you had no funding. But if you're happy to have some kind of organic growth and chip away at that finance, then at some point you should have where, okay, I think no more finance, I've got a good portfolio, let's work on some organic growth, let's chip away at the finance, get rid of all of the interest, and what you do keep is 100% yours. But I think to get off the ground, I think finance is very important, and those are really highly leveraged. Slight change in bank rates or interest rates, and suddenly they're in trouble. You understand? If you've got 10 properties all mortgaged, at 75, 80%, bank rates have gone from zero to, not zero, but, very low.
1.1.
Yeah, 1%, do whatever, all the way to 5, and I'm touching maybe 6%, and they're not on fixed rates. Suddenly they've got a situation. And even if they are on fixed rates, the moment those fixed rates lapse, for a short period of time, they're going to face perhaps a double, an increase, perhaps in, double in mortgage repayments. And suddenly they may find that the rent doesn't cover it. Tenants may not necessarily cooperate. Even if you increase the rent, the tenant may not be able to pay that rent. You've got a situation which you wouldn't have had if you had not leveraged to that extent. Now, if you got, 50%, arguably is better than 80%. But
but I suppose in real estate or any business, if you're not expanding, you are contracting. So you gave me.
But are you? I mean, you've still got
capital. Seems like it.
Well, you may not be expanding in terms of adding new assets, but you'd like to think that you've got capital appreciation, so you are expanding in that arena. All right. So as the assets mature in age and the years tick by, you'd hope the property values increase. So there's definitely an expansion.
But why stop at 40 properties if you can stop at 500 properties, for example?
Go for it. I'm not saying not, but you've got to be, I think, very careful, because if it goes wrong, it's going to go catastrophically wrong at that level, isn't it?
Then I suppose that
especially if everything's in one company, isn't it?
In that kind of circumstance, they can just reduce their loan to value, isn't it? Bring it to 50-50 perhaps?
You'd like to think so. I mean, you'd probably want to hit, a certain tipping point whereby the income being generated should far surpass, your loan repayments, and that should give you sufficient income, which can happen, to just clear off your loans and or expand organically, just with the surplus funds that are coming in over and above what you're getting in from rental income. So once you hit that tipping point, you've got enough to pay the rent, maintain your lifestyle, but you should still have a surplus sum which is left. Stack that up, and now you should be able to acquire assets on a cash basis, which gives you a far better negotiating position, because you can move quicker. Less strings attached.
Fair enough. I think from this conversation, you've shared so many tips. But I think it also brings to light that there are complexities that are to be taken seriously within real estate investing, that you also gave an example of can lead to imprisonment if you don't do it right in terms of managing your tenant, or could have your assets taken over by the bank. So it does definitely tell that it has a lot of complexities, and it does really require for an investor to have a strong and experienced legal advisor by his side to guide him throughout all of it, because an average Tom may not understand all the jargon that comes with all those contracts that lenders will even give you in the first place, or tenancy agreements. So I guess my final question to you is, what are the top tips that you'd give to an investor to use to establish which property conveyancer they should go for? What are the attributes someone should look for?
I think, look, if I was a client, you've got to get someone you have a good feel about. You know, they might tick lots of the boxes, big office, central postcode, etc. But I think personality is quite important. So if you don't have an affinity with that person from the moment you walk in, then I think you might want to. That's my first legal. Everything else to aside, you've got to have a bit of an affinity because you're going to have a very serious relationship with this individual. So you've got to be comfortable about the person's demeanor and who they are, etc., which you should be able to gauge within a few moments, I guess. Once that box is ticked, you want to get somebody, depending on what level you're coming into, who's actually a specialist in that area. You know, you've got to be an expert in that field. It's not something that does absolutely everything. You know, jack of all trades and master of none. You don't want somebody in that arena. So they're familiar with that territory. They've been doing it for, at least 10 years, ideally, perhaps. And have that degree of maturity. I think these are the top sort of tips I would say. And the first, like I said, it's a personal relationship because you're investing a lot of money. And you want to be able to access your lawyer, have a frank conversation, and feel comfortable with the advice you're receiving in return. And I guess alongside that, being able to get hold of them. So,
we do know that.
Lawyers can be hard to get hold of.
Yeah,
so it can be difficult. So you need someone you can communicate with, at least gets back to you in a reasonable period of time. So at least you can move forward. Because look, as lawyers, I think sometimes we lose sight of the fact that we may have multiple clients and transactions going on at any given moment. For that client, there's nothing more important in that client's life usually than that particular transaction. Even if something less as mundane as writing a will, or immigration application, or property transaction, invariably if they're going to see a lawyer, then that's probably the most important thing going on in their life. And lawyers can lose sight of that reality and say, look, you've got to understand that for you, it might not be as a lawyer, but for that client, it's the most important thing going on. And they want that time and a degree of attention to ensure things go through smoothly. So, yeah, I think
that is so true what you
it's not a huge list of things really, but, I think they would be right up there. And recommendation, I think, probably something else. So, perhaps not rely so much on Google and reviews, etc., but speak to other investors or people that you know. I think recommendation is very important because it's been tried and tested. So somebody's had a positive experience, and the hope is that by referring you'll also have that same positive experience. So I think personal recommendation is also right up there. Yeah.
The audience that have watched this conversation have really enjoyed it and have learned a lot off you, because definitely I have from this conversation with you. How can they get in touch with you?
How can they get in touch with me? Well, Green and Olive Solicitors. All right. So obviously my name's Arif Awad. My email address, should you require it, is arif@greenandolive.co.uk. We're at 4 Whittle Street in Birmingham City Centre, just at the bottom of Colmore Road.
Perfect. Well, I hope you all have enjoyed this conversation, have learned a lot from it. Arif is my solicitor. He helps us with all the acquisitions of the properties, with leases and so forth. So I can personally guarantee that you would not have any regrets, and I can fully recommend him. So his details will be in the description below. I hope you have enjoyed the video. Like, subscribe, and I'll see you in the next one.